Can you hear us, Mr. Ahmed?
Yes, ma'am.
Mr. Regier, this does come on for motion for judgment on bond in 2023 CR 488.
Judge, I have been in contact with Mr. Sweeney, and we have worked out what I think is a plea. And I think prosecutor in the courtroom is familiar with that or aware of that. If we're able to do the plea this morning, that would be great. We're prepared to do so.
Your Honor, I also have the bondsman here with me.
All right, what is the bondsman's name?
Philip Webb with Second Chance Bail Bonds. I have 3 on the docket today.
All right. Mr. Regier, how does the state wish to proceed?
Your Honor, insofar as the issue of a plea is concerned, the state is prepared to proceed today, at least on that issue. I have been briefed by my colleague regarding this matter.
Well, it doesn't look to me like he's been turned in on his bond.
Judge, could I address that briefly? When he missed his court date in December, he was in custody in Missouri, but I didn't have any evidence of that. I mentioned on the record that I thought he was in custody, but I didn't have record. Later on, I did get proof of that, and I did file that with the court that he couldn't have appeared because he was in custody. I filed a motion to set aside the warrant, and I thought that the case record shows that you granted that. You put the signature to set aside the warrant, but maybe I'm mistaken.
I think let me see, motion to set aside warrant due to defendant's incarceration. And well, looks like we did sign that. It looks like I did sign that and we did file it. Does he have any other warrants out though that we need to check on?
I'm not aware of any, and he hasn't disclosed anything in Missouri or Kansas to me that would be in a warrant status.
And Your Honor, if the court is considering that particular issue, the state would be requesting a clarification on the record from the court's perspective. I do note that it would appear that an order was filed with this court and signed by Your Honor on April 20th of this year. It does appear to address the issues raised by counsels, at least insofar as the cover page is concerned. However, in reviewing the order, it appears to stay silent on that particular issue. So the state would be requesting some clarification as to the court's perspective as to the current status of this matter.
All right, it looks like the warrant has been withdrawn and that we just need to show that is inactive. Jen, do you agree with that?
Your Honor, yes. I don't know if I need something from the county attorney's office or if I can just go off of that, but I am asking.
Well, I do have a signed order withdrawing the warrant, and it is filed if I'm reading it right.
Yeah, my understanding was the only thing that was left is that we didn't go through the process of getting a court date. If we had set that up earlier, then maybe we would have dealt with this issue earlier.
Okay, well, hold on. Jen, would you look at that document filed April 17th of 2025 and see if that doesn't suffice for what the clerk would need?
Yes, I will look into it.
All right, thank you. All right, so the warrant has been set aside. Motion for judgment being set aside, I trust.
One moment, Your Honor. Your Honor, is the court finding that in addition to setting aside its prior orders that the prior appearance bond for 2,500 professional surety is being reinstated?
Mr. Webb, do you have any problems with the court reinstating that?
No, I'm sorry. There was something in here that caught my attention.
Okay, then it is set aside. And that brings us to resolution of the charges. And you said there's a plea agreement. You want to announce that again?
I don't know if the state wants to put on the record what their recommendation is, or whether I should go ahead and do it. Which is the norm?
It goes both ways. Mr. Regier, do you have a preference?
Not at this time, Your Honor.
All right, then since you made it with his colleague, why don't you go ahead and announce it, Mr. Becker?
Okay, Judge, my understanding is the recommendation is that counts 2 and 3 would be dismissed by the state. Defendant would plead guilty to count 1, which is the possession of marijuana, the Class B misdemeanor. That the state would be recommending no fine be imposed. There would be court costs. Defendant would be ordered to pay the KBI lab testing fee. There probably would be some assessment for monitoring fees for the recommended 6-month probation. The prosecution would be recommending a 120-day underlying or backup jail, 6 month term, as I said. Conditions of probation would be to have defendant do a drug evaluation that could be done, since we're in the Kansas City area, that could be a Kansas City area-based drug evaluation as long as it's reasonable and appropriate. That he follow and complete any recommendations based on that evaluation. The state is not specifically requesting any testing. That would depend on the evaluation, whether the evaluator requires testing. Obey the laws of the country and the state. And no shock time is being requested. I think I've covered everything, Judge.
All right, Mr. Regier, anything further before I address the defendant?
Not at this time, Your Honor.
Very well, Mr. Ahmed, you can hear me okay?
Yes, Your Honor.
How do you plead to count 1, possessing marijuana in Butler County, Kansas on October 7th of 2023?
I plead guilty.
By pleading guilty, you are admitting that you did the act alleged?
Yeah.
Is anyone making you enter this plea of guilty by any threats or promises other than your plea agreement?
No, Your Honor.
Do you understand that with this plea, you will be giving up your right to trial? You will most likely be found guilty and unable to appeal the conviction. I'm sorry?
Yes, Your Honor.
Very well. Can you tell me where this happened in Butler County that you possessed marijuana?
Where did it was inside the car, but it was going towards Wichita, and we got stopped in the middle of Butler County.
All right, so you had marijuana in your automobile?
Yes. Yes, ma'am.
And where in your automobile did you have it?
It was in the owner center console.
All right, and it was your car?
No, ma'am.
But did you know it was in the car?
No, ma'am.
It wasn't your marijuana?
I guess in a way it was.
How so?
We was both using it. We both had it. I guess it was in the car.
Okay, you and the driver
Yes,
had
ma'am.
been using it together in the car?
Yes, ma'am. In
All
Kansas City, and it was
Okay.
just left in the car.
I see. So you knew it was there, you possessed it. Okay. And this was on the road. You got stopped somewhere on the road on the way to Wichita. Do you know if you passed Andover or Augusta or any of those towns?
I wouldn't know my towns out there.
Mr. Regier, do you know where he was to confirm jurisdiction?
One moment, Your Honor.
Judge, I can shed a little bit of light on that.
Okay,
I'm reading kind of a fuzzy version of the affidavit, but it was southbound I-35 mile post 1240 2, I think it says.
I
Uh,
see.
Yeah, I don't know the local area, but hopefully that helps a little bit.
Your Honor, may I?
Go ahead, please.
Your Honor, the affidavit in this matter appears to refer to the vehicle being located as it exited I-35 milepost 92 in close proximity to Cassidy, Kansas. The state's evidence is that is in Butler County, given this court jurisdiction. Additionally, the affidavit appears to refer to a pursuit that terminated in close proximity to El Dorado city limits.
Okay.
That sounds correct, Your Honor.
All right. So I find that the court does have jurisdiction, that the defendant has freely and voluntarily, as well as knowingly, entered this plea. And I do find him guilty of possession of marijuana, dismissing counts 2 and 3 for plea agreement. I will follow the plea agreement for sentence. Mr. Ahmed, you are convicted of possessing of marijuana. Therefore, your sentence will be 120 days in the Butler County Jail. I will suspend that so long as you successfully complete a 6-month reporting probation. And that probation, I will make that a 6-month reporting probation. Your first order of probation will be to call probation. Do you have a pen or pencil?
I can go grab them, man.
Please do. Everyone on here, make sure you have a pen and pencil every time you come to court, because you will always have something to write.
All right, let's talk about that. The hearing for State v. Ahmed had all the makings of a procedural tangle, but Magistrate Hilary Braley managed to untie the knots with a mix of patience and precision. The first order of business was sorting out a bond issue that had been lingering since Ahmed missed a December court date. Turns out he wasn't ignoring the court, he was in custody in Missouri at the time. Defense counsel had eventually provided proof, and the warrant was officially set aside, though there was a bit of back and forth to make sure the record reflected that clearly. With that hurdle cleared, the focus shifted to a plea agreement. The deal was straightforward. Counts 2 and 3 dismissed. A guilty plea to possession of marijuana, no fine, but court costs, lab fees, and 6 months of probation with an underlying 120-day jail term that would remain suspended so long as he stayed on track. Ahmed's allocution was almost disarmingly candid. He explained that marijuana was in the center console of a car that wasn't his, acknowledged he knew it was there, and admitted both he and the driver had been using it. When asked about the exact location, he confessed he didn't know Kansas towns well, prompting the prosecutor to step in with details from the affidavit to nail down jurisdiction. That cooperative moment between counsel and the bench was a reminder that sometimes the adversarial system can pause for a quick team effort to keep things moving. Magistrate Braley took care to confirm the plea was voluntary, entered knowingly, and based on facts that gave the court jurisdiction. She then laid out probation terms, with the clarity of someone who's seen plenty of avoidable violations. Starting with the instruction to always bring a pen to court. The atmosphere stayed calm throughout, with the occasional procedural wrinkles smoothed over by a mix of legal formality and plain-spoken explanations. No fireworks, no grandstanding, just a case resolved with a practical agreement and a clear path forward for the defendant. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.